Welcome. In this video, you will learn about the process by which an Indian custodian and Indian child's tribe can intervene in any state court proceeding involving the foster care placement of or termination of parental rights to an Indian child as defined by the Indian Child Welfare Act. Intervention is the procedure by which a tribe is recognized as a legal party to a child in need of aid case, as an example, and afforded the same opportunity as the other legal parties to participate. Within this context, we will focus on the right an Indian child's tribe has to intervene in cases to advocate for the best interest of its tribal children. The Indian Child Welfare Act grants an Indian child's tribe the statutory right to intervene in proceedings involving the foster care placement of or termination of parental rights to that Indian child. However, in order to do so, the child must meet the definition of an Indian child as defined by the ICWA itself, which is any unmarried person who is under age 18 and is either A, member of an Indian tribe, or B, is eligible for membership in an Indian tribe and is the biological child of a member of an Indian tribe. In other words, they must already be enrolled with the tribe or eligible for enrollment, and one of their biological parents are enrolled members. When a tribe intervenes in a proceeding involving one of its tribal children, it becomes a legal party to that case. This means that the tribe will be entitled to notice and service of all motions and filings, will have the right to access and review all previous court records and filings for that case, and it can file legal documents advocating for its position in the case or oppose the positions of the other parties. Intervention is important because it gives the tribe an opportunity to make its voice heard and to ensure that the court and parties to the case are informed on the cultural and social standards of the tribe. By intervening, tribes can advocate for the best interest of their tribal children, particularly with regard to ensuring they have a connection to their family and culture. Before we discuss how to intervene, you may wonder how tribes are to be notified of these proceedings, so we will briefly cover that first. In any involuntary proceeding in a state court where the court knows or has reason to know that an Indian child is involved, the party seeking the foster care placement of or termination of parental rights to an Indian child is required by law to notify the Indian child's tribe of the proceeding and their right to intervene. They must do so by registered mail with return receipt requested. If they are unsure which tribe the child may belong to, then they are to provide that notice to the Secretary of the United States Department of the Interior. The Secretary then has 15 days to provide the notice to the parent or Indian custodian and the tribe. Even after they put the notice in the mail, the proceeding itself cannot move forward until at least 10 days after receipt of notice by the parent or Indian custodian and the tribe or the Secretary. In Alaska, the Office of Children's Services employs their own regional ICWA specialists who are familiar with the tribes in their respective regions that can help OCS identify and notify tribes of any pending proceedings involving their children. Once a tribe has been notified of a proceeding and they have determined that the child is an enrolled member or has a parent who is enrolled, the actual process of intervention is relatively straightforward. Intervention can be accomplished by either filing a written notice of intervention with the court or even by making a verbal request during a proceeding, though best practice is still to have the order granting the intervention put in writing and signed by the judge. The image in this slide shows the Notice of Intervention template provided by the Alaska court system, containing all of the information tribes will want to include in their notice if they choose not to use the court's template. In addition to filing a notice of intervention, the tribe will want to file a designation of tribal representative. As its name suggests, this document designates the individual the tribe would like all legal documents to be sent. It also indicates what the tribe has authorized their designee to do in the proceeding, like filing documents representing the tribe's position and participating in court hearings. Just like any other legal proceeding, you will need to give the other parties in the case a copy of the Notice of Intervention and designation of tribal representative. This is called Service of Process. The image in this slide shows the Certificate of Service template form provided by the Alaska court system, and it includes all the parties you will see in most state court proceedings involving tribal children, although it is important to note that children are not always appointed attorneys. Service is required because it ensures that the parties in the case receive notice of what is being filed and to give them an opportunity to respond to those filings. Although parties can object to a tribe's intervention, the ICWA grants the tribe the statutory right to intervene, and this right is not subject to or limited by a party objecting to intervention. While it may differ in other proceedings, the Alaska court permits the tribe to accomplish service by emailing the documents they are filing to the lawyers and state agencies in the case. The only exception is when a party represents themselves without an attorney, in which case they will have to be served by mail or hand delivery unless they have explicitly agreed to service by email or fax. The Indian Child Welfare Act grants an Indian child's tribe the statutory right to intervene and become a legal party to proceedings in state court involving the foster care placement of or termination of parental rights to that Indian child. By intervening in these proceedings, tribes can advocate for the interests they have in the best interest of their tribal children, thereby ensuring their continued existence and integrity of the tribe. We hope this presentation has given you the knowledge and tools to intervene in ICWA cases for the tribe you represent. If you do not have your own forms to use for intervention, all of the forms shown in this video are available on the Alaska Court System's website, courts.alaska.gov/forms/index.htm. They can be found under the section for Child in Need of Aid cases.